Breaking news in one of the criminal cases against Luigi Mangione, the man who's accused of killing United Healthcare CEO. He's appearing right now in a New York City courtroom. Moments ago, the judge, Gregory Caro, issued a major ruling. He says state prosecutors will be allowed to use some key evidence recovered during his arrest in Altoona, Pennsylvania, back in December of 2024. But other key pieces of evidence will now be suppressed. Put simply, a partial win for the defense. So what stays in? Well, a firearm and notebooks discovered in Mangione's backpack. What is suppressed? Electronic devices, including his cell phone and computer chip, and the firearm magazine. The judge also ruled some of the statements Mangione allegedly made to investigators at that McDonald's will be admissible as long as he wasn't officially considered in custody at that time. The 28-year-old suspect has pleaded not guilty to both state and federal charges stemming from the killing of Brian Thompson outside a Manhattan hotel. Let's bring in NBC News legal analyst Danny Cevallos for more on these proceedings today. We're just digesting it now. Bottom line, this is a surprise that even the defense is getting some sort of victory here. And really, when it comes, let's start with the physical evidence here, things like the gun and the notebook versus the magazines, the wallet, the passport, things like that. It really comes down to what was actually confiscated at the McDonald's versus what was then later taken out of the backpack while he was at the police station. Walk us through this decision.
Exactly right. This is a surprise. These motions are rarely granted. They're very difficult to win. And even a partial win here is a massive win for the defense. And you're exactly right. So the Fourth Amendment prohibits searches without a warrant. But there are so many exceptions to the warrant requirement. And in this case, when they approached Mangione, once he was secure and the bag was 9 feet away, then they needed a warrant because it was no longer in what is called his grabbable area, his wingspan. If it's something he could theoretically still reach, like a firearm, then they can search it incident to arrest for obvious reasons, officer safety. But in this case, because he was secured, the bag's 9 feet away, they're no longer in officer safety land. So anything that was searched and discovered at the McDonald's essentially is being suppressed. But interestingly enough, once they take it back to the station and they conduct what's called an inventory search, they did that largely correctly. And they got to other evidence that they didn't look at McDonald's, including the firearm, which to me is the biggest piece of evidence that stays in. That will stay in because the inventory search was proper.
And that's what's interesting, maybe some people didn't realize about this case, was initially when they searched his backpack, the magazine was one of the things they found, but not the actual handgun itself. That was discovered later when they were processing the backpack back at the police station. Big picture, what does this mean for the case? Because I feel like if the gun stays in and the notebook stays in, which allegedly includes some writings about the healthcare industry and things that could go to motive, that seems like a big deal. But not having the magazine, not having the cell phone, the passport, the wallet, how could that hurt the prosecution's case?
Look, here's the thing. The prosecution has a lot of evidence against Luigi Mangione, but the defense here has done an amazing job. And obviously, I'm a defense attorney, so I'm a little biased, but I understand the uphill battle they've had at every turn. And this motion was always a long shot. And I expected, I said it on the morning show with you, Joe, that I expected this motion to be flat out denied, just as the similar motion was denied in federal court. So even a partial win, it doesn't mean the case goes away. As you know, the government or the prosecution still has a lot of evidence against him. And you're right, the gun, to me, is the most important. But that is the way criminal defense works. You chip away. You chip away. It's death by 1,000 cuts, figuratively. It's a saying. So you try to chop away at the prosecution's case. And two things can happen. Either the case might get too weak, or you can negotiate a better outcome for your client.
The defense is just looking for reasonable doubt in the mind of one juror, and that's what makes the difference here. So that's some of the physical evidence here. Another question was some of the statements that were actually made by Mangione, whether he had basically had his Miranda rights read to him at that point. And we again sort of have like a split decision. Some things will stay in, some won't. Walk us through that.
Joe, there's perhaps no concept more misunderstood by the public than Miranda. I can't tell you how often somebody will be arrested and they'll come to me or another lawyer and say, this has to be thrown out. They didn't read me my Miranda rights. Wrong. Miranda only applies when two things are present. Are you in custody and are you being interrogated? If police arrest you in another case and find drugs on you, they don't need to interrogate you. You had drugs on you. So the key here becomes statements must be Mirandized if you're in custody and being interrogated. And that's not always a clear line. So the Supreme Court has said someone's in custody when a reasonable person would believe they're not free to leave. And boy, is this a gray area. And it's evidenced by this decision. The judge concludes that until 9:47 a.m., when he was only approached by 3 officers who did not have their hands on their firearm. By the way, that's a significant factor. At that moment, he was not in custody. But if you look at that video, take a look at that video. If you're Luigi Mangione, would you feel free to leave with these officers coming up and talking to you? Probably not. Then they say at 9:47, once 8 officers are there, then he doesn't feel free to leave. So everything after 9:47 a.m. that he says is suppressed. Everything before, in theory, is voluntary because he's not in custody. He reasonably, according to the judge, would have felt free to leave.
A reminder here, we have a state case. That's what this case is. We also have a federal case, and the federal judge also looked into some of these very same issues and came up with a different conclusion. Walk us through that discrepancy and what that means.
Yes, motion denied in federal court, and a little while ago, in fact. And that was no surprise to me at all. And you have some slightly different analyses because you're in federal versus state court. You have some slightly different procedural issues involved. But you're exactly right. That creates a really strange dichotomy as these cases now move forward with some evidence suppressed in the New York case and virtually none of it suppressed in the federal case. That, again, is a bit of an inconsistency. But the reality is the federal government and the state government typically do not prosecute someone for the same occurrence at the same time. That's not something that happens very often. And I've been very critical of the federal prosecution in this case because, generally speaking, an alleged murder on the streets of New York is something that is the quintessential state crime. It's not really a federal crime. But they've made it into a firearms case, and they're prosecuting it at the same time, which they can do.
All right. So we, again, have a state case and a federal case. Right now, the state case is scheduled to go first. It's about 4 months away. What's next in this process leading up to the trial? We move inexorably toward trial. I don't expect there's going to be any offers considered. It's all or nothing for the defense in both cases. But don't be surprised if you see some last-minute continuances as well. Anything can happen in these high-profile, very complex cases. But I would expect that, especially the federal case, within the next 6 months, even if there is some minor continuance, we're going to see these cases go to trial. And I do not expect there's going to be any plea agreement unless, and this happens sometimes, a defendant gets to the eve of trial. We saw it in Koberger, saw it in other cases, and they say, you know what, I've just had enough. No mas, I'll plead.
We thank you for watching. And remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.